deals with the continuation of an inquest by a different judicial officer, and it makes provision where the judicial officer has died. And I will submit that the same practical issues will apply in this instance as well. And in the last sentence of subsection 12, subsection 2 of section 12, it indicates that the new judicial officer may cause any person who has already given evidence at the inquest to be subpoenaed to give evidence as if he had not before so given evidence.
Yes.
And I believe that deals basically with the reconstruction situation that was previously raised, and I will not move that application.
Thank you.
Thank you.
Okay. Advocate Jodas.
Thank you, my lord. Yes, it was good that we considered the matter of the reconstruction of the matter. The previous presiding officer had a very good summary of the evidence of Mr. Joao Rodriguez specifically, as well as newspaper reports for his recall. So I think it's more than sufficient.
Yes.
That time, my lord. So I'll leave it at that. I'd like to call Professor Don Foster, my lord.
Yes.
Professor Foster.
Foster. Do you have an objection in setting the vote? You swear that the evidence are about to give is the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say so. So help me God.
Thank you. Professor, you may be seated if you so wish.
Thank you.
Just make sure that when you speak into that microphone.
Thank you.
Thank you, my lord. Professor Foster, what is your qualifications?
I have an MSc degree from the London School of Economics, a PhD from the University of Cape Town, from the University of Cambridge, UK.
And social psychology, that's your field of
Social psychology was a specialization in both instances.
Right. And you've been head of the department and dean for a number of years, if you can just enlighten the court.
Certainly.
As to that, please.
I've been at the University of Cape Town in the Department of Psychology for 40 years. This year, the 40th year, I've been head of department on three separate occasions. They have a rotating headship. I've served as Deputy Dean, Faculty of Humanities, on and off for a period of about 10 years. I'm formally, officially retired, so I carry the rank of Emeritus Professor.
And just incidentally, you've done more than 160 publications, not so?
I have more than 160 publications. I've run out of counting.
Just to round off this, you also gave evidence in a number of criminal cases. About 24 of criminal cases you gave evidence, not so, Professor?
That is correct, my lord.
That just as a background as to your expertise, Professor. Now, Professor, you have done research on detention and torture in South Africa. And I think it's about 35 years ago that you did this research, not so?
Correct. If I may begin a story to the court, on completion of the PhD degree in the early 80s, returning to the University of Cape Town, and following the deaths in detention of, in particular, Steve Biko, and then on a later occasion, Agate, I think, in the early 80s, it became incumbent on at least some of us as psychologists to investigate psychological aspects that were underway in terms of security legislation in South Africa, particularly the holding of detainees. The voice that was missing in those years, my lord, was the voice of detainees themselves. That is, there was a good deal of noise from the state, from all kinds of parties, but very few ever heard the voice of detainees themselves. So it was my intention to investigate by interviewing political detainees, and that is what we proceeded to do in the early 80s, a period roughly from 1982 through to the first publication of the report in 1985. We interviewed security detainees in all major centres around South Africa: Johannesburg, the greater preponderance, Durban, East London, Port Elizabeth, Cape Town. So it was an urban-based study. We obtained former detainees simply where we could. It was a concentration on those that had been held under conditions for interrogation, Section 6 of the old Terrorism Act, and a handful of those under Section 29 of the new 1982 Act, but mainly for purposes of interrogation. I think 76% of cases that we interviewed were interrogation-related security detainees. We trained 9 interviewers extensively in a rather different method to interview detainees at some length. What we found in pilot work was that detainees objected, former detainees objected to being closely scrutinized and cross-examined. So a different approach was taken, and that is a rather open-ended interview situation which was far more relaxed for the political detainees. In other words, to put it in very ordinary terms, we asked them, what happened? What happened to you? Tell us what happened to you. We adopted a slightly different approach in viewing detention. We regarded detention as a process and not simply as a single event. Let me elaborate. Many people are put under stress before they are even detained. How so? Many of them are under situations of surveillance. Some of them are threatened with detention, threatened with arrest, and a whole series of events occur even before they're detained. So what we did was to draw a line to illustrate on a piece of paper and said, tell your story beginning before you were detained. What happened earlier on? Were you under surveillance? Were police looking for you? And so on. Then what happened at the moment of arrest? How were you arrested? What time? And we were searching for a detailed description of what had happened to them. So the general form of the interview was open-ended. All interviews were audio recorded and subsequently transcribed. From the transcriptions, we worked to code information to eventually produce a series of tables. For example, what actually happened in terms of kinds of torture, and later health symptoms during detention and health symptomatology after release from detention. So the study looked at a processual aspect of detention as a series of events, as sets of processes occurring over time.
Let me ask some pointed questions a little bit here, Professor. Now, this was an interdisciplinary study, eventually.
This was an interdisciplinary study?
Legal, historical, and then psychological.
That is correct.
Right. Historical and psychological, I take it that you were responsible for that.
That is quite correct, sir.
And before we forget about it, I know you said it was done from 82 till 85, but the interviews Does it relate to the 70s and people that were detained during the 70s?
Correct. The time period covered was from 1974 to 1984, so a decade. That is, detainees who were detained from 1974 through to 1984, that decade.
You eventually published a book called Detention and Torture with contributions of Judge Dennis Davis and
Correct.
Diane Sandberg.
That is correct. The book is as follows. It is by Don Foster, myself, and assistance from Dennis Davis, who's now a High Court judge, and the research assistant at the time was Diana Sandler.
My Lord, I beg leave to hand it up as Exhibit K. Exhibit K. We were still busy with the interdisciplinary study. It was under the auspices of UCT, not so, Criminology, Institute of Criminology.
Correct.
Can you just elaborate on that, please?
Certainly, although I was based in the Department of Psychology, the Department of the Institute of Criminology, Dirk van Zyl-Smit as director, was keen to house the study. In other words, to look after the administrative aspects, to look after the financial aspect, and he was quite keen to put a roof over the head of the study. In other words, to look after the procedural aspects, administrative aspects of the study. So it was done under the auspices of the Institute of Criminology, and it was the Institute of Criminology that produced and published the initial report in 1985, late 1985, somewhere around September, October 85.
And this was all done according to the principles of the social sciences. Scientifically done in accordance with the social sciences.
That is correct, my lord. It is an empirical study. The one that we are concerned with here is an empirical study that is separately, we looked at legal aspects, separately we looked at historical aspects from the beginning of security law way back in the 50s and the progression of increasingly draconian legislation over time. But the study, the particular study that is rather unique in this aspect is the empirical study, and by empirical, normally philosophically, is meant simply information taken in through the sensory data system. In ordinary parlance in the social science, it's through observation. And the observation in this particular case was interviews with the former detainees.
And incidentally, I think all 400 interviews are still available at UCT, not so.
All the interviews are still available. The sample size, and so for any further reference, my lord, the sample size was 176 cases of security-related detention, mainly interrogation. However, a handful were repeatedly detained, so we interviewed 158 individual detainees, but we referred to the data, the unit of analysis is 176 cases of detention.
What was the purpose of this empirical study of you, Professor, if you can just elaborate? What was the purpose of your book?
Primarily to hear the voices of security-related detainees. These had been muffled at the time. I was a psychologist. It was apparent that psychological techniques were being used in security-related detention, and it became incumbent on us to hear from detainees themselves what psychological and physical aspects pertain to their experience of detention.
Yeah, incidentally, even before the Ravi Commission, the voice of the detainees were not heard.
That is correct, sir. They were not heard.
You refer to the Timor matter, I think, on page 27 of your book when you discuss the political, the historical context. If you can just look on page 27 of your book.
Certainly.
The top paragraph, I think, from about the second sentence there.
Right.
After a period of relative politically calm from the mid-1960s to the early 1970s,
Right.
and then in 1971, the security police raided the homes of 150 people of all races in various parts of South Africa. At least 7 people were detained in terms of Section 6 of the terrorists, one of whom, Ahmed Timol, died. And then you also refer here to Dr. Salim Esop's case, not so?
Yes, correct.
Now, but I have a few questions for you. What do we mean if we say that detention is a closed system? What do we mean if we say detention is a closed system?
Closed, by describing detention as a closed system, I refer to three things. The first is the legal situation. The legal situation, particularly under Section 6 of the Terrorism Act, which was in effect reenacted as Section 29 in the early 80s, meant that legally one had no access to detainees. One couldn't put motions in a court of law to produce the body of a detainee. The legislation, the security legislation, prevented even legal access. So the first aspect is an enclosed system which was covered by law. The second, and the most important for our purposes here, is that the detainees were entirely in the hands of the security-related officials. Not only the security police, but of course the handful of doctors and any other personnel that may have been brought in. Only later, after the death of Biko in 1978, and yet again in the early 80s, were systematic regulations brought to bear whereby there were visits, and even in that case, the visits were usually the form of other judges, people within the legal structures. That is, very little independent access. So the 3 tiers of this closed system of detention is 1, legal, 2, the security personnel themselves, the security police. In fact, detainees were entirely in the hands of the security police in terms of any decision. They could be held incommunicado, they were held incommunicado, they were held for lengthy periods, and those periods could be renewed. Even from as early as the original 90 Days Act and then the 180 Days Act in the early part of the 60s, these detention orders could be renewed. In other words, they could be held almost indefinitely without being put through a court of law, without being subject to the access to the normal process of justice. The third aspect of this, what we describe as the closed system detention without trial, is the experience of the detainee. Detainees would have felt enormously vulnerable in such a situation. Very often they were held in solitary confinement or in places away from other detainees, and therefore not even having access to the support of other detainees, let alone families, legal operative, anybody on, if you like, their side of the fence. This was fenced off.
Yeah.
So detainees
support
would...
committees, the detainees,
Sorry.
the parents, the detainees parent support committee also only came later. As a
Detainees Parent Support Committee only came later, and even so, that was simply offering support upon release from detention. But within the system of detention itself, it was a closed system. The media didn't have access, you couldn't report. We did not even know in some of these occasions whether the person had been detained or not.
With your expertise, Professor, I must ask you the question. Does detention provide potential hazards to the mental and the physical health of detainees?
Indeed, that is what we surmised at that case, and this is what we further investigated by interviews, and we'll speak to the results shortly. Yes.
Yes.
Yes, sir.
You can go over to the results. What was the results, if you can just tell us exactly what did you find because of your research?
Very briefly, just to touch on what we were talking about as the process. We found, for example, that indeed matters before detention and the early phases of detention were pertinent. That is, people did experience surveillance on the part of security police, did experience harassment, investigation, threats. They were already being watched in many cases before they were detained. The process of arrest was often hostile, often late at night, often aggressively done. This would send a clear message to the detainee that you're now in the hands of authorities who are hostile. The main set of findings for our purposes here may be discussed in terms of the table that we provide on page 102. The incidence of reported physical torture. Just before I proceed to that, my Lord, I should say a word about the generalizability of this particular sample. The sample that we interviewed, 176 cases of detention, we assessed this against all known population parameters of detainees between 1980 and the end of 1982. The reason we did not investigate the wider population from 74 to 84 is very often that information was not public. Very often in a given year, there was no public reporting on parameters of the population. In many instances, our sample matches closely in terms of age, in terms of gender, in terms of racial category, in terms of areas of involvement in activism and work. In all these respects, this can be regarded as an adequate sample in terms of generalizability to the wider sample of security-related interrogation sections. So, having said something about the sample and the generalizability, we've turned to the key findings. Of the sample, 83% reported being subjected to some form of physical torture. Let me pause here and say, I differentiate physical torture from psychological torture. United Nations definition of torture has recognized psychological aspects as well. We will touch on that shortly, and we'll probably spend less time on that. I simply want to say at this purpose that from the point of view of the detainee, there is no separation between physical and psychological. It is all one package. It is what happens to you. So when I'm reporting this, I'm artificially making a distinction between physical torture and psychological. Having said that, these are the general findings of the sample as a whole. 83% experienced some form of torture. In terms of frequencies, the most common forms of torture were as follows. Beatings, 75%. Let us just pause there. That includes a whole range of things, including pushing, shoving, slapping across the face, beating around the head, punching, kicking. The mule kicks that is referred to in Ahmad Timur's case would fall under that category, for example. The second most frequent category, forced standing. The third category maintain abnormal bodily position. I think somewhere in this case there is reference to detainees being forced to sit on imaginary chairs. If I could enact it, it's to be told to sit in this kind of posture. Apart from being a ludicrous posture to sit in other words, embarrassing and degrading in many aspects. Of course, this can be highly debilitating physically, and when you are kicked in a position like this or punched in a position like this, one is extremely vulnerable. Forced gym exercises, bag over the head, the famous method in the Cape, electric shocks, food deprivation, and we can pause here and recall that a number of these occurred in the case of the former detainee who reported earlier in this case. We can touch on that and say there's a checklist that was experienced, and these are likely to have been kinds of things that Ahmed Timur was subjected to. Strangulation, suspension, there are all kinds of different modalities of suspension. One of them in the South African situation, and we may in parenthesis say, these are the same methods used all over the world. Other studies have shown very similar methods and similar frequencies of methods. When we talk about suspension, there are a number of ways, but a key way was to put a broomstick between the knees of a person here and here, and to suspend them on a stick, and then to handcuff the person onto that stick as well, and you're enabled to swing them around, in fact, and parts of South Africa this was called the helicopter method. Dreadful and of course highly debilitating. So the bland word suspension covers a whole series of further aspects. Cold water, sometimes we've heard in this matter as well, also urination, where people, instead of pouring cold water over people to revive them, they also urinated over them. Water deprivation, application of cigarettes, chemicals, bright light, excess cold, excess heat, and so on.
I also want you to touch on the psychological forms of torture. If you can just run down through the psychological, I think that we find it 105, page 105.
Certainly. First of all, I could summarize psychological aspects in terms of 4 categories before I go to the actual details, and say that psychological torture, which for years was not recognized as a form of torture, and this study was one of the first in the world that started to put clearly on the map the notion that psychological aspects should be regarded as part of the total package recognized as torture, partly on the back of United Nations definitions. So, the 4 major classes of forms. The first involves communication, usually distorted communication. I'll give examples in each case. For example, one form that was widely used in the Eastern Cape was to inform you that the police would kill members of your family. Now, it's a form of lying. It's a form of distorted communication, but it can be enormously stressful to a person who knows that they're held totally in the closed system of detention. That's the first form. All kinds of distorted forms of communication. False accusations, offers of threats, bribes, all kinds of forms of false communication. If I could pause here, my Lord, and try and take an everyday example. In our everyday life, we often refer to people close to us to verify reality. And we also have access to newspapers and the media, and these are forms of testing the veracity, the veridical aspects of reality. However, when you're held in a closed system of this sort and then subjected to distorted or false information, it can have a very powerful effect. So the first category is this distorted communication. The second category of psychological aspects are mental weakening aspects. For example, use of drugs, the use of sham execution. Quite often they put a gun to your head and say, we're going to kill you.
Or they hang you over the stairs.
Or they hang you over the stairs. Or in Albie Sachs's case, way back in Weinberg, he wrote a book about it, and Albie Sachs was indeed also dangled over a stairwell by his legs and threatened with being dropped. There are a whole series of forms of mental weakening devices. One of the most powerful, of course, is sleep deprivation. The lack of sleep is probably among the most powerful of all devices. And of course, it's a physical aspect, but it is also a very powerful psychological weakening device. Being deprived of sleep, being deprived of food, being deprived of water, being told to stand, the statue form of torture for stand on bricks or simply stand on one leg for hours and hours on end. All of these aspects are mental weakening devices. The third category could be called psychological terror tactics. Again, sham executions, extreme stresses, being knocked around, threats of killing of the family, and so on, all kinds of devices which could be put under the form of psychological terror tactics. It is to put extreme fear, stress, anxiety in the minds of detainees with worries that this will be continued further. Simply threats that we will prosecute. Threats in those days of being prosecuted and life sentences on Robben Island or all the rest were all part of the standard baggage. The fourth category of psychological devices would be regarded as degrading devices, humiliations, being forced to undress, electric shocks to the genitals, being bitten extraordinarily by dogs, being subjected to animal bites of various sorts, humiliating postures, as I've said before, nakedness in various forms. There are all kinds of degrading devices, degrading to your religion, for example, degrading to your family. People would make degrading remarks about your mother, for example. And in a closed system, these degrading aspects are... So the details, I'll just read out a few of them. Solitary confinement, verbal abuse, threatened violence, the alteration between good and bad interrogators, misleading information, the witness or the knowledge of others' torture. Very often detainees claimed that hearing the screams from cells down the corridor was enough to put them into a state of absolute terror. Or witnessing, as in the present case, witnessing, getting a glimpse of another detainee who can hardly stand and is being supported by members of security police. This kind of witnessing is a form of, again, psychological terror tactics. Threats of execution to the self or the family, offer of rewards, undressing, constant interrogation. Constant interrogation is a form of weakening, mental weakening device. And one of the aspects of this case, we've heard that the interrogation went on and on and on in a fairly unbroken fashion. What needs to be said here, my lord, is just one thing. That one of our findings was that interrogation is very largely conducted by teams. We think very often, because we see certain movies of an individual policeman interrogating an individual subject. These are the films perhaps from abroad. The fact of the matter is that our study revealed that interrogation is conducted by teams. Furthermore, the teams often rotate in terms of 8 hours on, 4 hours off, 4 hours, another team moves in. So it is quite possible to have extended periods of fresh interrogators, but an absolutely debilitated, exhausted detainee.
I don't want to dwell too long on this, and we also got to touch on some of the theories. You've looked at post-traumatic stress syndrome, and you also looked at learned helplessness. All those things you made applicable to the consequences of detention, not so, Professor?
That is correct. All these theoretical aspects, and I do not wish to detain the court here on such matters. The matter of theory is long and complex and rather tedious, and I don't think helps us in this particular matter. But there are a range of theories from the 1950s on up to the present day in trying to account for why detention is stressful. The crux of it is that our claim here and our findings are that detention is a highly stressful situation. It works through the operation of stress, whether the label is DDD, debility, dread, and whatever, or it is post-traumatic stress disorder. The technicalities needn't involve us here. There are a range of theories.
Yeah. I think in your conclusions you also say it's harsh. But let's quickly skip. Chapter 5 of your book relates to the empirical research that you've done, not so. Page 86 of your book, you set out exactly how the empirical research was done. Is that not so?
Correct.
And the way you sampled, you set out exactly how you constituted the sample, and this was done in accordance with the prescripts of your social science.
That is correct.
Okay, and you set out exactly in table format the sample in gender, comparisons of the distribution and the type of detention, and the other tables that you I want to take you through to your conclusions, and that's in chapter 7 on page 153. Tell us in your own words, after you've done your research according to your social sciences, what conclusions did you make regarding detention and torture in South Africa?
The conclusion we drew from this research, in a nutshell, was that torture formed a relatively systematic and widespread form of abuse during security legislation over this period. That is, we're talking actually to generalize from the 60s onwards, well into the 80s. This conclusion then dated 87. This book was published in 1987, and I quote, "Results provide clear evidence that both physical and psychological methods of torture are employed on a widespread and fairly systematic scale in South Africa. The number and the range of health problems, both during and following the release from detention, indicate the severity of treatment at the hands of security officials. We need to say as well that in the appendix I give results of other studies elsewhere in the world, but these results are similar to other highly stressful situations and other research reporting on particularly stressful situations. This is not unique research to South Africa. There are not many studies, at least in those days, this was a long time ago, 30 years ago, not many studies, but there were a handful of studies internationally, particularly those studies showing that the health symptomatology post-detention was remarkably similar in other samples in other parts of the world, Chile, South America, different parts of the world where torture was used. Now, detainees can't manufacture this. They're not skilled medical operatives. So if they're reporting similar kinds of symptomatology, it adds support to the validity of this particular study. The findings, to repeat, there is systematic torture conducted through South Africa in security legislation in this period.
I conclude my evidence in chief in that, my lord. I see it's 11:10. Maybe we should take it to you, George.
Yes. We'll proceed with the questions after this. Professor, you come back at 11:30 for us to continue the questions. We are adjourned until 11:30.
She's thrown.
Former head of the Department of Psychology at the University of Cape Town. 40 years at the Department of Psychology. Not covered the same year. No. 1974, just after. But most of the people we interviewed were held under Section 6 of the the same conditions that other material. So we expect conditions will be
gesê om dit want hulle het al die sake teen hulle teruggetrek en net daar gelos is 'n
Dis julle bonus, los dit aan hier. Asseblief dis 'n bonus.
Ek het al daai iets gedink, jy weet ons moet dit nie daar.
One, two, one, two, one, two, one, two, one.
Dit is moeilik, soos ek sê, ek self is deel van die stelsel.
Ja.
Ah, that's a white balance.
We're going to speak to Mapaila now then, yeah? Oh, 1 2 1 2. Can you hear me? 1 2 1 2. Gerecht, man gut.
Tell them to call me back, okay?
Okay. Okay. Marilyn, do you have time for a guest? You don't want to do it.
They haven't called me.
You haven't called her back. Is this yours?
So this was a very dangerous study to do. I mean, what I haven't said is that, and I was put under immense pressure at the time as well.
Yeah.
Death threats for 5 years, and
Jeez.
that I didn't. I'll leave out of the court for the moment.
Yeah.
You can imagine the security
Yeah,
police
yeah.
were not
Yes.
happy, and even today they would not be.
Yeah.
There might be certain members in this court.
Yes.
So even today, I don't feel entirely secure. And in those years, certainly.
I can imagine. Yeah. You just have to listen to the testimony of the people that were tortured the first week.
Horrendous. I simply can't believe it.
Yeah.
Nike and
Yes.
no.
Yeah.
No, this brings back even to me.
Oh, yeah, I'm coming. I was just waiting for hours.
Yes, apparently the judge wants to see us. Sorry, can you do me a favor? Can you put this over there? Morning. Apparently the judge wants to see us.
Masha, can you catch? He speaks the business.
people we interviewed here were held under Section 6 of the Terrorism Act, which are the same conditions that Ahmad Timur was held under. So we expect that the conditions would have been broadly the same. The same conditions pertain to incommunicado detention. That is, no access to family, lawyers, any support, any help. You were locked away in the hands of the security police. So the conditions were exactly the same under which Ahmad Timur was held.
As a result of police action. Police action, but that's like action on the scene, though. That's action on the scene.
Thank you very much. As soon as possible, as long as I can get away about 1 o'clock. Car I parked is at the Manhattan Hotel.
Professor, still under oath. Mr. Vanni?
Thank you. Professor Foster, your book has a section dealing with the inadequate safeguards in place to prevent physical torture of detainees. More specifically, you set out certain inadequacies in laws and regulations to prevent the following. One, the psychological torture and abuse of detainees. Two, inadequate laws and regulations to ensure appropriate medical care of detainees. And you also point out various other inadequacies. I want to focus just on the failure to prevent psychological torture and abuse of detainees for the moment. Would I be correct in saying that these inadequate laws and regulations actually encouraged such torture and abuse in those days?
Certainly, my Lord, certainly they would have created a climate in which it was possible.
And can you describe to the court why these laws and regulations made it easier for both physical and psychological abuse to be carried out?
To repeat, in a sense, what I said earlier, it's the closed system of political detention in South Africa. That is the lack of access to the old legal requirement of habeas corpus, or being able to produce the body by lawyers. So the lack of access to independent medical officers. This would have promoted a climate in which it was possible, in which security police would at least have believed that they may act with impunity.
In your book, you also make reference to the Rabi Commission of Inquiry into matters related to the operation of South African security laws. You seem to be saying that there were some significant shortcomings in that particular commission. Can you highlight the main ones?
I just want to say this for the court. All of these events occurred later.
Yes.
Certainly after the events that concern this particular inquest. I just want to note that and say that these events, the series of events were as follows: the death of Bika in detention, and then certain inquiries that started to say what is going wrong. The Rabi Commission and reports from the Detainees Parents Support Committee in the 19th. So the inadequacies, at least one of the chief inadequacies, was not to hear from detainees themselves. There were other inadequacies of not getting independent legal advice. There were a series of criticisms by certain lawyers over the years. It wasn't the first time. And if I could just make mention also of a United Nations report published in 1972, which details 74 pages, we list it in the book, 74 pages of details describing torture in the years 67 to 72. So there was other criticism at the time that was not adequately dealt with by the Rabi Commission.
And in preparing for this particular testimony that you're giving us today, did you have occasion to look at the affidavits of Salim Essof and perhaps some of the other torture victims who have supplied evidence to this court?
I have had a speed read of such evidence, yes, my lord.
And in terms of the types of torture that were alleged in those affidavits, would you say there was considerable or substantial overlap with the types of torture that you have highlighted in your book?
Indeed, that is correct.
And so would it be fair to say that certainly in apartheid-era security detention, those types of torture were common practice?
They were common practice. That is my chief claim, my lord.
Are you aware of a South African Communist Party doctrine or policy or perhaps instruction or directive to its members that if they are detained, interrogated and tortured, that they should rather commit suicide than betraying their comrades or the party?
I saw this document in the pack given me in preparation, but I can't speak with any authority on this. I don't know it from first hand. I can only surmise that I have no knowledge of it, really.
Right. So in the research that you and your colleague carried out, you never came across...
I did not come across that, nor any similar device, no.
Nor in relation to any other party, ANC
no,
or whatever?
No, indeed, no.
And finally, these...
I was aware, if I could just add a point here, that the body called the Detainees Parents Support Committee, including, among others, David Webster, who himself was assassinated, you will recall, in the apartheid years. The DPSC provided information to political activists as a partial preparation for dealing with detention. That information was a fairly accurate portrayal of the kinds of symptoms that one could experience during the course of political detention, but there was no talk of committing suicide, nor suicide as a way out of detention, certainly not.
Thank you. So these very serious practices that you've highlighted in your book, are you concerned that some of these practices of torture in police custody are still taking place in South Africa today?
I've read newspaper articles to that effect. I have no personal knowledge, but certainly I've read allegations to that effect. There was a study conducted by the University of the Western Cape in the 90s. The author was Fernandez, Professor Fernandez, as I recall, which did look at torture by ordinary policemen in the post-apartheid period. But that's a long time ago. That would be the early 90s. I don't know. I do know there was a major study, again from the University of Western Cape, literally about a year ago. I remember appearing at a briefing and helping them prepare documentation. University of the Western Cape, let's say about 18 months ago. So there has been recent documentation. In fact, that legal centre at University of Western Cape has provided a historical set of documents of all the years prior and then up to about 2015. So we could get such documentation.
Well, we will be submitting an annual report of IPID, the body that deals with policing complaints,
right,
the 2017 and 18 year, which suggests that there are some 223 cases of deaths in police in custody for that year that are being investigated. But there are some 2,550 cases of assault being investigated by the police. And apart from those assault cases, some 27 cases of torture alleged against the police which are being investigated, which suggests that not all these practices have been eradicated.
Correct.
My Lord, no further questions.
Thank you. Yes, Mr. Kutsu.
Thank you, my Lord. I've got only a few questions. Sir, in your study, your empirical study, did you use a baseline of normal detainees? In other words, detainees that were not necessarily political detainees or security-related detainees, to see the effect of normal incarceration and detention of ordinary criminal persons?
No, sir, we did not. And as an aside, I should say, in an unpublished, we'd never published this piece as I recall, we simply took an ordinary sample of students at the University of Cape Town and the University of Western Cape, as I recall, a long time ago. And we gave them a checklist of health symptoms, similar to the health symptoms reported here. And of course, very few of them reported such symptomatology. But no, sir, we did not conduct a, as it were, control group.
Yes. And this detention and torture, and I'm more specifically referring to the 70s and 71, that period, or the period that you looked at, was this a unique thing to South Africa, this form of detention and torture?
Was it unique to South Africa?
Yes.
No. No, sir. Somewhere in this book we list something like 98 other countries that have been reported by Amnesty International. There have been the annual reports of Amnesty International. The sad truth of the matter is that this form of abuse is very widespread. It has been historically, and it is very widespread in the world at that time. 1970s.
So during your research, so did you at all consider or investigate the prevalence of suicide during detention? And I'm not differentiating between security detention or normal detention, but suicide within the structures of detention.
No, we did not investigate this. I'm aware that such studies have been done, but we did not investigate it. No.
Thank you, my Lord. Please. Questions on that?
Yes, thank you. Just one question from me. The pieces of legislation that were applicable.
I'm slightly deaf, sir, sorry.
The pieces of legislation that were applicable at that time.
Yes.
You spoke more of the Terrorism Act, Section 6 of the Terrorism Act. Then it was followed by Section 29 of the Internal Security Act.
Correct, sir.
Now, Internal Security Act in an amended form is still in place today. Have you conducted a study to see whether the conditions of a detainee under Section 6 of Terrorism Act would be different now in terms of the measures that have been placed through amendments?
I have certainly not conducted such study, and I know of no such study.
Okay.
We, somewhere in the book, we make a distinction between the years, different years of detention, and so we actually have a comparative table somewhere that compares those detained earlier and those later. I'm just trying to see if I can find such a table. But as I recollect, we did not have enough sample size to make such comparisons meaningful. The crux of the answer to your question is no, we don't really know.
No, thank you very much. Any questions?
No re-examination, thank you.
Thank you very much, Professor.
Thank you.
Yes,
Thank you.
yes. Next witness, is it Mr. Vanni's witness?
Your Lordship, with the leave of the court, we'd like to call our next witness. That is Frank Kenyon Dutton.
Yes.
My full names are Frank Kennan, K-E-N-N-A-N, and my surname is Dutton, D-U-T-T-O-N.
Do you have any objection in taking the oath?
I don't.
Do you swear that the evidence that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Please raise your right hand and say, so help me God.
So help me God.
Thank you, Mr. Dutton, and you may sit down.
Thank you, my Lord. I prefer to stand for the moment.
Thank you, my Lord. With your leave, I'd just like to hand up two documents, as we may make reference to them during the course of Mr. Dutton's evidence in chief. My Lord, the first document is a blown-up photograph of room 1026. It comes from the book authored by Mr. Imtiaz Kaji, Timol, A Quest for Justice. And the blown-up photograph can be seen adjacent to page 97. And we have marked that document as C8.
Yes.
Then the next document is the police file for one J.Z. van Niekerk. And that document is marked J2. And I can confirm that all my colleagues have been given copies.
Yes.
Okay, I've just been passed a note that Mr. Dutton wishes all of us to speak as loud as possible, and I will endeavour to do so. Mr. Dutton, did you make out an affidavit for purposes of this inquest?
Yes, I did.
And do you have a copy of that affidavit?
Yes, I do.
And you confirm the contents of this affidavit as being your affidavit?
Yes, I do.
My Lord, for the record, this affidavit is part of volume H of the record. It's marked H7.
7, yeah.
Mr. Dutton, we need to deal with your expertise and your personal background, and your affidavit discloses a great deal of background dealing with your professional career. It's a very interesting and distinguished career, but time doesn't really permit us to go through it piece by piece. But what I'd like to do is just to highlight some aspects, and perhaps you can confirm that they are indeed the case. And if you wish to add, then please do so. You describe yourself as an international policing and investigation expert, and that you've carried out complex investigations in South Africa and a range of other countries, Bosnia, Croatia, Kosovo, Sudan, Afghanistan, DRC, and a number of other countries, too numerous to mention.
That's correct.
Other highlights, you've been in the South African police force before it became a service for some 38 years, and you were also the first head of the Director of Special Operations, also known as the Scorpions.
That's correct.
And you received the Order of Baobab in Gold from the President of South Africa in recognition of your policing work locally and abroad.
That's correct.
You joined the police on the 1st of August 1966, and you carried out your police training for 1 year, and thereafter you did general policing duties in various places.
Yes, that's correct. I did a year's police training in 1967.
Thank you. And that covered all basic policing activities.
Yes, it did.
And you commenced work as a detective in 1971.
Yes.
And during the course of your work, you had occasion to investigate hundreds of political violence cases, some of which involved cover-ups.
Yes, as from 1985.
85. And more particularly, those cover-ups involved police cover-ups. Is that correct?
Yes, correct.
In 1992, you headed up the KwaZulu-Natal investigation team for the Goldstone Commission. And can you just describe to the court what did that commission do, and more particularly, what were you investigating?
The commission was a commission to inquire into the causes of violence in South Africa. I was appointed as the head of the investigation unit for KwaZulu-Natal. And I might add that State Advocate Pretorius was on the secretariat of that commission.
And you also headed up an independent investigation to look into hit squads within the KwaZulu Police.
Yeah, that is correct.
And then from 1996, you were seconded to the United Nations International Criminal Tribunal for the former Yugoslavia, where you investigated genocide, war crimes, and crimes against humanity in Bosnia and Croatia. And ultimately, you commanded all field investigations in Bosnia, Croatia, and Kosovo. Can you just describe briefly what kind of field investigations these entail?
Well, the one were when the refugees were being forced out of Kosovo by the Serb security forces, and they were flooding over the borders into Macedonia and Tirana at Skopje in Macedonia, and going into refugee camps. And we were collecting evidence from them concerning the method and the way in which they had been expelled from Kosovo. So that was the Kosovo one. In Bosnia, there were continual investigations in Bosnia, but included amongst that, of course, was the exhumation of mass graves.
So you were investigating the likes of massacres and other atrocities, so you would say that you are quite familiar with crime scene investigations?
Yes, I am. And in fact, in Kosovo, it was a very interesting crime scene investigation because it entailed the whole country.
You returned to South Africa in December of 1999, and that's when you were asked to establish and head up the Scorpions, which you did so until 2004 when you resigned.
Yes, that's correct.
In broad strokes, can you just advise the court what have you been doing since your retirement?
Well, since my retirement, I've been acting as a consultant investigator to a lot of different organizations, the United Nations Development Program, the Global Funds, which distributes aid in respect of TB, AIDS, and malaria. For MONUC, where we investigated sexual offences. I've been appointed to head the investigation units into different commissions of inquiry, one in Darfur and the other in East Timor.
The Darfur inquiry, that was appointed by the UN Security Council?
That was appointed by the UN Security Council.
And I understand you've also been involved in reforming the police force for the island of Seychelles.
Yes, that is correct. Initially, I was employed by the UN to do an assessment of the police force in Seychelles, and after that the Seychelles government employed me to implement the recommendations that I've made.
And currently you're investigating rhino poaching on behalf of the provincial government of KwaZulu-Natal, and you're also a member of the National Planning Commission.
That is correct.
In your affidavit, you have outlined that how you got involved in the Ahmed Timol matter, and that ultimately you were instructed to collect new evidence for the purpose of reopening the inquest. It's all set out in great detail. There's no need for us to recount that in oral evidence.
That is correct.
But perhaps there is something emerging from your account of what you did, which, amongst other things, was to track down Mr. Salim Essop. We heard evidence from him in the first week, as well as a number of other victims of torture who were detained at John Vorster Square. Why did you feel it important to take their statements and ensure that they were submitted to the inquest court?
When I started the investigation, I was given a lot of material. The original inquest documents, those that do exist. I was given the book written by Mr. Kaji. I was also given a book that was written by Mr. George Bisos, and in particular the chapter on Indians Can't Fly. And it became apparent to me that the people that had been detained had not been called as witnesses to the original inquest, even though they were available.
And what were the implications of that, Mr. Dutton?
Well, the implication of that is that the inquest court couldn't have arrived at a proper finding if they hadn't heard all the witnesses.
I want to turn to a part of your affidavit where you suggest that the death of Mr. Ahmed Timol in police detention ought to have triggered 2 investigations. Why do you say it ought to have prompted these 2 investigations, and perhaps describe to the court what these investigations ought to have been?
Well, the one investigation is obviously the death and the cause of death, and if anybody was responsible into the death of Mr. Timol. But there's another aspect as well, which under police regulations, any police officer who allows a prisoner to escape, that is a departmental investigation. It's a disciplinary offence. So by Mr. Timol exiting through the window, it is effectively an escape from custody. So there should have been a departmental investigation looking at different issues to what the inquest should have looked at, although often those issues would have been parallel. But there should have been, the departmental investigation should have looked to see that all police instructions were obeyed, the standard operating procedures were obeyed, that whether Mr. Timol was restrained, whether there were sufficient guards guarding him, issues like that. And that inquiry, in my view, ought to have ended with some of the members having disciplinary steps taken against them.
And to the best of your knowledge, and the investigations that you've carried out, have you found any evidence of such a disciplinary inquiry?
No, there was no disciplinary inquiry held.
Or rather administrative inquiry which could have resulted in discipline?
That's correct.
And in fact, you go so far as to say that certain individuals should have been particular subjects of such an inquiry. Your statement suggests this at paragraph 26. These are Captains Van Niekerk, Gloy, and Sergeant Rodriguez. Can you explain why they should have been subjects of an administrative inquiry?
Well, from the inquest, it appears that they were the people that were in control of Mr. Timor.
And you also highlight that, and this you get from the founding of the inquest magistrate, that the police regarded Mr. Timor as a valuable find that the police wanted to keep.
Yes,
so
that's
are you
correct.
suggesting that because of the status of Mr. Timor, that really should have called for an administrative inquiry?
Most definitely.
And do you have any idea why there appears to be no such administrative inquiry?
Well, the only reason that I can think of is that it was a part of the cover-up, because that inquiry ought to have taken place, particularly because Mr. Timor was such an important arrest for the security police. The security police at that time had been struggling with bucket bombs going off in different cities, sometimes simultaneously. And it was a huge embarrassment to the security police. And so when Mr. Timor was arrested and identified as the head of the cell, the main unit in South Africa, he obviously was a suspect in all these bombings. And by him escaping and being killed in his escape, placed the police in a very bad light.
And if there had been a serious, methodical administrative investigation, could it have potentially uncovered evidence that could have been of use to the original inquest?
Yes, definitely.
Let's now move on to the actual investigation into the death of Ahmed Timor. You have reached the conclusion that the investigation that was conducted at the time amounted to a cover-up of the truth.
Yes.
And what you do in your affidavit is that you set out what should have happened in that investigation, and you set out certain following basic requirements and steps. I think it really is important that you take the court through those steps and explain why you think these certain steps should have happened.
Certainly. It is important for any investigation, but particularly for an investigation into a death of a person, to be considered impartial and thorough. To achieve this, it needs to meet at least the following basic requirements. The investigators must be independent and as impartial as reasonably possible. All available evidence must be collected, preserved, and presented to the inquest court, including all potential witnesses must be interviewed, their statements obtained, and they must be made available to the court. There must be a very thorough scene of crime investigation. A thorough and impartial post-mortem should also be held. All relevant material must be made available to the inquest court.
Thanks.
I've made notes on the independence and impartiality of the investigation, and although in 1971 it would have been challenging for the South African police to have selected a truly impartial investigator, however, they could have taken steps to try and achieve this. They could have brought in an investigator who had built up a credibility and a reputation for fair investigations from a different part of the country, possibly, and an investigator who had a proven track record. The South African police at that time had many very qualified investigators who could have conducted an investigation like this. Although this wasn't done at the time in 1971 in South Africa, but since this investigation was important, not only because Timol was an important prisoner, but also because of the repressive laws that existed in South Africa, and particularly the detention without trial, that when a detainee died in custody, it put the government and the country under a lot of pressure from international organizations, from other nations. It also persuaded anti-apartheid people to enhance their resistance. So if the South African police wanted to demonstrate to everybody that this was indeed a suicide and not a killing or through torture or any other means, then they should have sought an impartial investigation. And to do that, they could have selected, for example, a credible independent lawyer to act as an observer to the investigator. They could have brought in an international police officer to act as an observer. They didn't do that, and instead they appointed General Bass, who headed the detective branch at Pretoria headquarters. And General Bass very quickly demonstrated that he was in fact not impartial, because he made a report to the Report newspaper that he believed that Timol had committed suicide, and this was right at the beginning of the investigation, a conclusion he should not have reached at that stage.
And what impression would that have left in the minds of the wider public?
Well, the impression it would have left, and which I think it did leave, is that the investigation wasn't impartial.
Just turning to the question of taking statements from security branch members, you say that they only took statements of security branch members who were directly involved in one or another way with Mr. Timol. What should they have done?
Well, that's rather like if you have a death in the bedroom of a house, and the only people you talk to are the people in the bedroom and not in the people in the other parts of the house. So in this case, they should have spoken to everybody on the 10th floor. And they should even have made a chart, what each person was doing and where they were on each of the 5 days that Timol was in detention. They should have asked them what they heard, whether they heard screaming. They should have asked them, had they seen anything unusual? Had they seen a man with a blindfold walking down the corridor? Did they see a man that had to be supported because he couldn't walk properly? Have they seen any torture apparatus? All these questions should have been asked of everybody on the 10th floor, at least on the 10th floor.
And why do you say it's surprising that no black police members featured in the investigation?
I know that, I don't know the exact number, but I know that there was a large contingent of black members that worked on the 10th floor who were attached to the security branch. And it's surprising that none of them made a statement. None of them were approached for their view or for what they knew about the death of Ahmed Timol.
You make reference to the police version dealing with a Mr. X. And according to the police version, accepted by the original inquest court,
yes,
was that once Mr. X came into room 1026, where Timol was present, and announced that he knew where Quinton and Henry Jacobson were, that apparent or alleged startling news prompted Mr. Timol to exit the building through the window and commit suicide.
Yes.
So you raise a number of questions which I think are disturbing ones. And can you take the court through the questions that arose in your mind in relation to this Mr. X?
Well, Mr. X was obviously a very critical witness, if that version was true. And a statement should have been recorded from him, and he should have been made available to the inquest court. No statement was taken from him. He didn't appear before the inquest court on the basis that it wasn't in the interest of state security for him to appear. Now, this is surprising because at that time, and right through the 1980s, the security police made use of secret witnesses in court. And these witnesses would give evidence in camera, or they would give evidence in various ways so that their identities wouldn't be revealed. Mr. X could similarly have given evidence at the Timol inquest, and it surprises me that he didn't.
On that very point, could there have been any law at that time which protected witnesses such as Mr. X from making statements or being identified? Was there, to your knowledge, any law or police regulation or police policy that would have prevented it?
Not that I'm aware of, my lord.
As a court, please.
Can I comment further?
Yes,
about
please,
this?
please do so.
The other surprising thing about Mr. X, if he was such a secret witness, if he was, for example, an undercover agent that had infiltrated a community or an organization, then it's completely illogical that he should go up to the 10th floor where there were numerous detainees being held and go to the door, go into the office where Timol was being held and make this announcement, because it would just mean that at a later stage Timol could have disclosed that Mr. X was a security branch agent. Any one of the other detainees who happened to see Mr. X could also have disclosed his role. Now, undercover agents are used in police forces throughout the world, but an undercover agent never goes to a police building or to a police office because of the danger of it blowing his cover.
So, what conclusions do you draw from this scenario?
Well, I wonder whether Mr. X actually existed.
Indeed, in your affidavit, you go so far as to say that the Mr. X version is a concoction devised by the police to explain the suicide of Mr. Timol.
Yes, exactly.
And investigating the wider scene, what do you think the police ought to have done? And when I mean the wider scene, around the building, perhaps.
Well, the investigation shouldn't have been restricted to the 10th floor. It should have been widened to the entire John Foster Square. There may have been people, policemen or visitors to the police station standing in the grounds that might have seen the fall. There may have been people, as we heard, for example, with Advocate Mattis, who happened to see the body falling when he looked out the window. So there ought to have been office-to-office inquiries done at John Foster Square to see whether anybody had any information that could assist the investigation.
And what about simply walking across the road from the impact zone to ask people in shops and filling stations and others
Yes.
Given that it was during the daytime, anybody might have heard or seen something.
Yes, exactly. And that ought to have been done. You know, appeals could have been put out to the public to come forward with information if anybody had seen anything significant. Nothing like that was done.
I mean, isn't that the most basic, elementary, 101 of investigations, that you do reach out and you do start talking to people in the vicinity?
If you want an investigation with an accurate result, you have to reach out to people. And the wider your reach, the better your result.
Let's turn to the scene of crime or incident investigation. What would be the most important sites of a crime scene investigation in this case?
Well, apart from the body, which I won't discuss because that is the post-mortem examination, but certainly there were 3 crime scenes. One is the place where Timol actually fell, the place his body or his person came to rest on the ground. The second is the office where he was held and from where he allegedly jumped, at office 1026. And then at least of the John Foster Square Police Station, the 10th floor. So then I discuss where the body came to rest. Now, factually what happened was that Timol's body was removed within minutes from him falling. If there were compelling reasons to move Mr. Timol, the position of his body ought to have been marked, either using paint or using tape or using rope or something. It's a very common thing that we all see on TV. You have a body lying on the carpet, taped out.
And it may seem obvious, but why would the police want to mark the position of the body?
Well, because you want to preserve the scene as best as you possibly can. And if there was a compelling reason to remove the body, you would want to record where the body was for your scene of crime investigation. The scene of crime investigation is where one gets your best evidence in terms of forensic evidence, which is more reliable than oral evidence.
And what else should have happened at the crime scene?
The crime scene, a plan ought to have been drawn of where the body lay and measurements taken between key points so that later, even 46 years later, you could reconstruct that scene exactly.
And what about...
Sorry? So, and then, of course, the scene should have been photographed. And properly and thoroughly photographed, not 2 or 3 photographs, hundreds of photographs. Every aspect of the scene should have been photographed.
While the body lay there?
While the body lay there, yes. And that again it's easy to reconstruct the scene from photographic evidence, where, for example, a shoe may have laid, or where a wristwatch fell, or any other aspect, the branches of the shrub that apparently were stripped. All these things should have been properly and carefully photographed.
But what if it happened perhaps in the late afternoon? We know that the police say he fell at around 3:50 p.m. Nightfall was approaching. I think that is probably disputable. But let's assume that it was close to night time. Is that a good excuse not to photograph?
No, it isn't. The South African police in 1971 were in possession of floodlights. They could have floodlit the area for photographs. And obviously, flash photography was in use in 1971. So the other alternative is you could have kept the scene exactly as it was until morning. and that is often the case that one does.
You mentioned something from Brigadier Patel's evidence. He spoke of an indentation in the earth, which indicated to him where Mr. Timol had fallen. What do you say should have been done in respect of that indentation?
Yes. Brigadier St. John Patel testified that he didn't see the body in sight, but that he had found an indentation on the ground which indicated to him where the body lay. Now that indentation should have been examined forensically so that it could be reproduced, the depth of it, so experts could be called in later on to examine the indentation and the hardness of the earth to determine whether that indentation was made by a body falling, rather than maybe somebody scratching out an indentation.
So the depth and position should have been measured?
Yes, very important.
And you
it might also have indicated the position in which the body fell.
In the absence of tape measures and photographs. You also mentioned that certain steps should have been taken in relation to bloodstain on the earth.
Yes, I understand that Mr. Timol bled while after the fall. I think it would have been important for samples to have been taken of that blood and for it to have been compared to the blood of Mr. Timol. At that time, they didn't have DNA technology, but they could do blood grouping. And that would have assisted one to come to a conclusion, a strong conclusion, that the body that was in the mortuary, the person identified as Mr. Timol, did actually fall in that position.
You also make mention of the position of windows in the building itself. Why was this important?
Well, the position of windows, whether they were open or closed. Advocate Mattis testified, for example, that he looked up and he saw that the windows were all closed. If that is in fact the case, then Mr. Timol couldn't have exited from a window. And conversely, if there were open windows or a open window, it would support the case that he did exit from a window.
And also, if the position of windows in the building had been recorded, we get a better idea as to whether Mr. Timol might have bumped into or hit one or more windows. Exactly. Coming back to photography, you've spoken about the crime scene itself, but your statement says that there should have been more photographs taken of the surroundings. Why is that?
Well, there should have been photographs of the surroundings. I've mentioned the shrubs. There should be of the wall, if there was any wall, how close the traffic was from the road, was from where the body lay. Photographs of open windows. So just generally anything of interest, and not only of interest, to record those photographs. So if, for example, now, 46 years later, we want to see if there was an open window or something protruding against which Mr. Timol could have fallen, we could examine that photograph and find out very clearly what the position was.
And why do you say an expert on trajectory of a fall should have been secured?
Well, that is also very important in a suicide case where there might be doubt as to whether it was in fact suicide or he might have been pushed, to find out how far he landed from the building and whether that trajectory, according to an expert, is where he would have likely have fallen. The only position that I know of in this particular case is Brigadier Patel, who said the body lay 10 feet from the building. And he also observed damage to the shrubbery. So it may be that the police, needing to account for injuries to Mr. Timol, needed him to fall through the shrub. And a trajectory expert would be able to say whether it was feasible, whether he could have fallen through the shrub.
Let's turn to room 1026,
Yes.
the so-called second crime scene. And can you take us through, and this is at page 24 of your affidavit.
Yes, again, photographs and plans should have been properly drawn and prepared of every aspect of the office, including windows, position of telephones, position of filing cabinets, positions of waste paper baskets. Everything should have been recorded. The office should have been forensically examined for fingerprints and blood stains. I know that Brigadier Patel says that he did an inspection for blood stains. That's not sufficient. A forensic expert needs to look for blood stains, because there's a possibility that if there were blood stains, they might have been cleaned, and a layman wouldn't see those blood stains. The forensic expert would be able to find them. The office should have been searched for items such as food, food wrappers, drinks and containers, drink containers and clothing. Any recovered clothing that might have belonged to Timol should have been forensically examined for blood stains, for body fluids. It should have been examined for signs of violence, tears and rips. The contents of the waste paper bin ought to have been very carefully checked. Timol was sitting at the desk, and according to the evidence, he was busy writing statements. He could have written a suicide note and dropped it into the waste paper bin. But we don't know whether anybody checked that. The phone number and the last numbers it dialed, I can't remember in 1971 whether the telephones had recall capacities. I think they did. But in any event, assuming that they did, those numbers should have been recorded and investigated. The window through which Mr. Timol jumped ought to have been forensically examined for fingerprints, blood, and traces of shoe polish and mud. If he went through that window, Mr. Timol would have left forensic traces of him leaving that window. Those examinations weren't done. The precise position that the investigators found the window in should have been recorded. Was it fully open? Was it closed? Was it halfway open? Was the latch tightened? How easily did the closing and opening mechanism work? And all these aspects should have been noted.
And you have made reference to the 10th floor, but just take us through the more specific investigations that should have happened on that 10th floor.
Well, an inspection should have been held of the entire 10th floor, looking for any unusual or suspicious item. There could be torture apparatus, electric shocking machines. There could have been bags, hoods for a person's face. There could have been blindfolds, and all these things should have been looked for. Mr. Timol was held on that floor for almost 5 days. I think it was 4 hours and 17 minutes. Evidence of his presence and the nature of his detention should have been closely examined on that floor, including what food he ate, were there plates, were there knives, were there forks, could food be warmed there or cooked, was there tea and coffee making facilities, how many mugs were there, were fingerprints taken of the mugs. toiletry items. Did Mr. Timol have a toothbrush? If he had a toothbrush, it should have been examined forensically for traces of blood, especially because we've heard that he may have been bashed around the mouth. The bathrooms and toilets should have been examined very closely for blood, particularly basins. In the trap below the basin, even the minutest amount of blood can be recovered and identified forensically.
Let's turn to the moving of Mr. Timol from the point where he impacted the garden. There is evidence from the police that he was moved very quickly and taken first to the foyer of the building and then subsequently moved to the 9th floor. Now, you state that as far back as 1967, when you did your police training, you were taught basic first aid. And on that course, what were you taught about what to do when coming across somebody with very serious injuries?
In 1967, as in previous years and years afterwards, it didn't continue for, I don't know for how long it continued, every police recruit was taught basic first aid. The course lasted for 6 months, and there was a period, I would think almost every day, but maybe not every day, maybe 4 days out of 5. A period of 40 minutes devoted to first aid. I was in an English-speaking troop, and our troop chose to do the St. John's ambulance course. The Afrikaans students chose to do the Noordhulpvliege course. Both are very similar. We were taught various things about bandages, and had to do bandages to scalps and to arms, and pressure bandages and all sorts of things. But the one thing that remains very clear in my mind is that we were taught not to move people who had very serious injuries. And it's something which played out in my police career. After my training, I went to Greenwood Park Police Station. And I was soon either a crew on a police van, or in fact the driver of the police van. And almost every day we attended car accidents. And people were very often very seriously injured in accidents. And we didn't have to practice the first aid we were taught, because an ambulance service would arrive very soon after the accident, soon after our arrival, and indeed sometimes they arrived before our arrival. So there was no real need for us to practice it. I can remember one occasion when I did practice it, and that it wasn't very successful in this way, and that is that I came across a motor accident within seconds of it happening, and the passenger, front seat passenger, had gone through the windscreen and cut his throat, and blood was just pumping out of his throat. And I tried to put pressure on the wound to stop the bleeding, but it didn't work. I mean, the blood just pumped out. It's like trying to stop a hole in a garden hose. But within minutes, a doctor arrived at the scene, and he took over from me. But this person unfortunately died soon afterwards. So we didn't move patients unless we had to. And as we heard yesterday, if a person was lying on a very busy highway or on a road, and there was a very real danger that he might be killed or further injured by passing vehicles, then we would move him. So when I saw in this particular case that they'd moved Timol's body so quickly and in a blanket, because we were taught and we witnessed it, and I was part of it. When the ambulances arrived, they put people onto a board and or alternatively into a stretcher. And they were very careful about it. So why Timol was put onto a blanket and carried away, I can't understand that. And I can't understand what the reason was.
Especially when he was lying in a garden some distance away from the traffic, so there was no danger that he would be hit by a moving vehicle. And we will need evidence on this point. There appeared to be no barrier in those days, so an ambulance could easily have stopped fronting onto the garden, and he could have been moved in an emergency vehicle for emergency treatment, or he could have been treated on the spot.
Yes, well, exactly. I'm quite certain that in Johannesburg, I haven't got any experience of it, but I'm quite certain that in Johannesburg, within minutes, an ambulance could have been there. We certainly know that Dr. Kemp arrived at the scene within 10 minutes. Now, why these members felt it important to move Timol in the manner that they did to the foyer of the building, I can't fathom it. I can't understand what they were trying to achieve. They said that he had a pulse rate, or they felt a pulse. He should have just remained where he was until help could have been brought to him.
Well, in your statement, you go further to say that, in your view, as an experienced officer, moving Mr. Timol in those circumstances is consistent with an intent on the part of those involved to ensure that he did not survive, and it's conduct, in your view, that is consistent with a cover-up.
Yes, most certainly. I think that by moving him, the crime scene investigation couldn't take place, couldn't occur. I might mention that I know that Daisel, the person that felt the pulse, that he had first aid training at Police College. And he certainly knew that he shouldn't do it.
Let's return to Quinton Jacobson. And you'll recall that this is the individual.
Sorry, before we go there, I want to add something to this.
Please do.
If Mr. Timol died on the scene, then of course he should have remained there. I think we've discussed that, but I just want to point that out. Even if he died, there was no reason to move him. And in fact, all the more reason to leave him where he was, because police protocols are that a crime scene remains exactly as it is.
And indeed should remain a crime scene until the investigation is there or complete, no matter how long it takes.
Exactly.
And in your experience, sometimes how long can these crime scene investigations take?
Well, I've been involved in investigations where the crime scene investigation can take up to a week.
And everything is left as is?
Everything is left as is. And great care is taken, great care is taken in recording precisely where each little thing is.
Would the body in those cases stay there, or would it be removed once it has been properly marked?
The body would stay there for as long as necessary, and it would ultimately be probably one of the first things that would be moved, but not quickly. There's a lot of forensics that have to be done on the body before it's removed, and the positioning of the body would be properly recorded. Obviously, photographic evidence would have been obtained of exactly where the body lies.
Thank you. Returning to the facts around Mr. Quinton Jacobson, and we have already spoken about Mr. Jacobson and Mr. X, so we won't revisit those facts. You point out in your affidavit that the police viewed Mr. Timol as the head of the main unit of the SACP in South Africa, and that Quinton Jacobson was a co-conspirator of Mr. Timol. But you raised doubts about that conclusion. Can you explain why you are so doubtful?
Yes. I think it was Gloy and Van Niekerk who said at the original inquest that they had reason to believe that Quinton Jacobson was a co-conspirator. And they'd also indicated that they believed that the mere mention of the fact that they now knew where Quinton was, in their opinion, prompted Timol to leap out the window. Now, Quinton was subsequently arrested after the death of Timol. And in Quinton Jacobson's Department of Justice detention file, I found that there was a letter. It's a letter of motivation to the Secretary of Justice from the Security Branch dated the 8th of November 1971. And it is said that Quinton and his group, because Quinton wasn't arrested by himself, initially he was arrested with, I think, 4 other people, had been found in possession of the document Inkululeka, sorry, I can't pronounce it properly, number 1. Now, and this was a letter from Brigadier Kruger to the Secretary of Justice in paragraphs 77 to 78.
Just for the record, Mr. Dutton, that would be volume B, my lord, exhibit.
Sorry, could I have some more water, please?
I beg your pardon, Your Lordship, it's volume L, not volume B.
Yes, I see here in the notes it appears as volume L. Yes. Are you referring to the Inkululeko document? Or reference to the file of Quinton?
Yes.
Oh, yes.
It's the letter from Brigadier Kruger to the Secretary of Justice, page 77 to 78.
Yes.
My Lord, my Leonard Jr. has alerted me to the fact that that was an error which we meant to correct. It should be it should be exhibit G7. That's the police file for Quinton Jacobson. I suppose the Department of Justice file for Quinton Jacobson.
Yes.
Please proceed, Mr. Dutton.
In the letter, Brigadier Kruger says that Quinton and his group were found in possession of Inkululeko number 1. Now, if this was so, we know from the inquest, and it's not disputed, that Ahmed Timol produced Inkululeko number 1, and he distributed it. So if that pamphlet had been found in the possession of Quinton Jacobson, it would certainly establish a link between the two of them, between Ahmed and Quinton. Now, the Secretary of Justice writes to the Minister, and he repeats this, and says that Inkululeko number 1 was found in possession of Jacobson and his group. But surprisingly, when Quinton Jacobson is prosecuted and charged, He's charged by himself, but he's not charged for possession of this pamphlet. Now we know, too, that the pamphlet was a communist document, and the possession of it in 1971 was illegal in terms of the Suppression of Communism Act. And the possession, the mere possession of that document was a serious offence, and the possessor was likely to face a lengthy term of imprisonment. Looking at the judgment for the case concerning Quinton Jacobson, Timol doesn't feature in that at all. There's no link between Timol and Quinton. And so that really takes the legs out of the version that the mere name of Quinton Jacobson startled and frightened Timol to such an extent that he jumped through the window. There's no evidence of any connection between the two of them.
In your statement, you say that this version is most likely a crude fabrication on the part of the security branch. You stick with that assertion?
Yes, very definitely.
Lord, we're approaching 1 o'clock, and before I get into the next line of questions, I wonder if we shouldn't take our lunch adjournment.
Are you going to be a while with what's remaining here?
I would say probably about another 15 minutes.
Well, no, then we may have to take an adjournment. We'll adjourn until 2 o'clock, 1400 hours. Rise.
We're still waiting for the following transcripts. So there's 4 volumes. Are that the complete transcripts? Just the 4 volumes. Yeah.
Howard,
We talked about the consult too.
you've got problems of this thing. Not negative problems, positive problems. You need time to go through.
We'll talk about it once you're interested.